Former Principal Chief James Floyd, welcome.
James Floyd, it's a pleasure to be here this morning and speak with you. And we'll talk about sovereignty this morning, and more importantly, the recent McGirt decision from 2020, and also the Murphy case. Those are two cases that worked their way up to the Supreme Court, that ended in the Supreme Court's landmark decision, reaffirming that the tribe's reservation status has never been diminished or taken away, and opened the door for a new page in our history for sovereignty and our exercise of our governmental rights. So I'll talk about those briefly this morning. I'd like to begin, though, to recognize and thank the staff of the Attorney General's Office of Muskogee Creek Nation. Those folks worked tirelessly on both the Murphy and McGirt cases, in addition to their average daily workload. So we relied upon them, and I relied upon them very much, and I think they deserve a lot of recognition for just the hard work and all the shoe leather and everything else they put into this case, because they worked holidays, weekends, long hours during the week to ensure that these cases got the attention they deserved, while they were also serving all the tribal and citizens' needs. So I wanted to first and foremost thank them and a big ado to them, because they really put the effort in to have the outcome that we did on the McGirt decision. So I'd like to talk about just kind of a brief history of our sovereignty, because it played a big part in the Murphy case. And the Murphy case was, just to give a recap of that very quickly, was a capital murder case that occurred in McIntosh County. Mr. Murphy was convicted by McIntosh County, received a death sentence for his murder case, and then it was appealed starting in about I think 1999. So his appeals of the death sentence first went to the state of Oklahoma, and then ultimately to the Supreme Court, but also the 10th Federal Circuit Court in Denver. So the Murphy case was really the case that put the foundation in place for the McGirt case, which followed later. McGirt was a member of the Seminole Nation. His crimes occurred within Muskogee Creek Nation. So those two cases are very pertinent to my discussion here this morning. As we talk about sovereignty and we celebrate our sovereignty, I think it's important that we always remember and to celebrate those whose shoulders we kind of stand on for sovereignty. Because, prior to removal, we had a government, we exercised our sovereignty. We were pretty much decimated and destroyed by the removal from 1825 all the way to 1837, a time that we were forced to come to Indian Territory. But then once we arrived here, we quickly established our own government. The Creek Nation Council House, the structure that we have right now, was shortly after the Civil War it was built, and remains today, and receives a lot of visitors who want to know the history of our government. We lived that history. Our ancestors were very active post-removal in establishing the government, negotiating with the federal government. The Treaty of 1866, the last treaty our tribe had with the government, and then subsequent efforts trying to work against the Enabling Act, the one that provided allotment, the one that enabled the state of Oklahoma to come into existence. And during that time, our citizens were active. After the Civil War, groups that opposed allotment. You had the Chitoharto and his group You also had the Four Mothers Society, which is kind of not spoken a lot about our history, but these were our citizens who banded together, and even with other tribes, to try to plead with the government to recognize our treaties, particularly the Treaty of 1832. And so we were active at that time in expressing our rights under sovereignty. That the Enabling Act and the Dawes Commission kind of seemed to steamroll us into allotment and then subsequently state of Oklahoma. So we were here, years before the Indian Territory became a state. So we've been active in that. We continued after statehood, even though the state of Oklahoma believed our government would disappear. They took the council house, they took all the property of the tribe and he sold it or disposed of it or used it in some way. So we didn't have that. But even under the appointed chiefs, after the state of Oklahoma came into existence, we were active. And I remember as a young kid, my parents and other family members being active in efforts, kind of ground level efforts for government. And I was fortunate to come to work for the tribe in the 70s after our government was reestablished. And at the time, our present constitution was voted on and approved. So, feel very blessed that I was part of our history during that time. And then the establishment of the government as we see it today and the exercise of our sovereignty. That history played an important part in both the Murphy and McGirt cases. And so I'll quickly kind of go through that and give you some of my personal experience as principal chief and some of my observations as well. So my first recognition of the existence of our reservation came much before I was a principal chief. As a child, as a candidate for the principal chief, when I'd meet with citizens, they would school me that our reservation status was intact and never taken away. I heard that several times, numerous times, before I became principal chief. I remembered that as well. It left a very strong impression on me. It reminded me of what I was even told as a child. Shortly after I became principal chief, I began receiving several letters from an attorney asking the nation to join with them in an appeal of the Murphy case that was going to the 10th Circuit Court in Denver. In the beginning, the initial letters were, I thought, kind of sketchy. No disrespect for the attorney, because the attorney that was representing Mr. Murphy had been in that case for years, had a proven track record herself, and so I think she was also formulating her own argument before the circuit court and would write me several letters and kind of describing where they were and asking for our support and to join her in that appeal. So in midsummer of 2016, we decided to join that case. It wasn't a tough decision, but I knew it was the right decision to make, but I felt it was risky. I felt that we had maybe a 50% chance of prevailing. On the one end, if we prevailed, well, we know what we're enjoying at this point from the decision, but I felt at that time that if we did prevail, and the rule of law, which I felt was very strong in our favor, provided that our reservation boundaries were still intact, our government was going to be stronger, and our citizens would benefit from that. So I knew that could have happened if they chose to study the background of the rule of law for us and rule in our favor. On the other hand, if we did not prevail in these decisions at the circuit court level or at the Supreme Court, it was going to be, I thought our future was, maybe going to sunset in that regard in terms of our government. It could be taken away from us, not just piecemeal, but it could be totally wiped out. So it was a dilemma, personal dilemma, my staff's dilemma, and so there came a point when we had to make a decision, and I chose that we would join that case. And then I also notified the other 4 tribes because they were very interested in this case as well, but hadn't joined the case. And we proceeded. We worked very closely with the Seminole Nation because they had strong support of our efforts, and so as well as the other 3 tribes. But I think Seminoles came first, and then we started working with the other tribes. When the case was argued before the 10th Circuit Court, we were one of the parties. One of the groups that helped us during that time and monitored the case and was local was the Native American Rights Fund and their attorneys out of Denver. That was basically in their backyard, the circuit court. So they assisted in providing us some insight into the kind of the environment of that court, the players of that court, and the case itself. And so, they were very helpful to us at that time. We also brought in several attorneys. The first group, and the one who stayed with us throughout the case and continues to some degree with the tribe now, is Kanji and Kotson. And Riaz Kanji was very instrumental in this case, and his staff, the other attorneys, Gershengorn, Tinker, those guys were very knowledgeable and helpful to us, and so I want to make sure they're recognized. As we monitored the case through the 10th Circuit Court, as principal chief, I'd get briefings from my staff, from the Attorney General's office, or we would be on phone calls with various groups like NARF that would provide us an update. When the decision was reached out of the 10th Circuit Court, and we examined that, we read the decision. I've read it personally. I've read the entire case of the Murphy case, from the crime that was committed all the way to the 10th Circuit Court. So after work, I'd take this case and go home and read it till all night if I needed to, because I wanted to make sure that I understood the case as well. Because again, we had a lot at risk, and I really wanted to understand the whole environment of this case as it went forward. Once we had the decision, then we knew that the next step was going to be the Supreme Court. And the case was ultimately heard before the Supreme Court in November of 2018. I was present, the Attorney General was present, the Light Horse Chief was present, and Councilmember Del Beaver was present, with a few others from the tribe, as we sat there and listened to the oral arguments of the Murphy case. I don't want to skip over that, but a lot of preparation went into that moment before the Supreme Court, and I'll briefly go into how we structured our strategy to prepare for the Supreme Court. One of the strongest cases we felt that we could provide in an argument to the Supreme Court was a history of us and our activism, our government, our culture, our traditions, our values, all those things we wanted to make sure that we displayed. So a lot of effort was expended by the staff, the Attorney General's office, practically everybody in the cabinet of the administration of the Principal Chief's office was involved to some extent. Law enforcement was one of the key pieces we wanted to make sure that the court understood. So at that time we had about 50 agreements with various other agencies within Muskogee Creek Nation and the state of Oklahoma with law enforcement. These cross-deputization agreements were a key piece of our strategy because it showed that we could work with other governments. They recognized us and they would work with us on making sure that we had law enforcement services, and so the citizens were protected, and for the lawbreakers that they were arrested and prepared for prosecution. So that was key. The other was just to make sure that the court understood us as people. So our traditional grounds, the ceremonial grounds, and the structures, the Mikos and their roles in our government, those things were also presented in our brief to the court because they were important. It showed that we had this continued government authority and exercise from prior to removal, the values that we had, the things that we did today. So they would look at what we displayed at the council house. And so we wanted to make sure that we presented the best picture and the true picture of our tribe, our government, and what we did on a daily basis to the court. That was very important. As a side note, one of the things that we also recognized during that time is that as we prepared, the opposition prepared, and were watching everything that we did, that they could see that was public. In a sense, we had to kind of lock down a lot of doors that came into the tribe, not the physical doors, but we had to examine what we did, what we said publicly, what we said in interviews to newspapers, televisions, our own media, what they presented, what visitors to the council house saw. We wanted to make sure that we were aligned with what our strategy was, and our strategy reflected who we really were. So we had to examine all of them. And we had to be very careful because internationally, there are people from other countries that would come into our website and look at what we had, and we didn't know exactly what they were doing, but we could track the number of hits that we had on our website and where they originated from, so that we could look at who was looking at us, because they were looking to pick us apart. And so as we prepared a very strong case, they were looking at how they could piece by piece kind of pick it apart in an argument before the Supreme Court. As we prepared the case, other groups became very interested in what we were doing. And so what initially began as maybe 2 of the 5 tribes, and then quickly the 5 tribes just kind of expanded nationally. And we had a process to look at people who wanted to be a part of this case, particularly those that we wanted to make sure had strong arguments in briefs that would support our case, amicus briefs. We had at one time, I think, over 300 groups that wanted to join us. And so we would have meetings about which groups were going to be in our arguments, because the Supreme Court would only allow a certain number, and which ones would not be. It was very interesting, and also sometimes kind of humorous that somebody who might have been a law student or just an entry-level lawyer wanted to be a part of this case, and some of the outlines of the draft briefs they had were, they were out there, I'd say it that way. And it's almost as if they wanted to hook their careers onto this case, and if we won, then take credit for what they did. We knew that wasn't what we were looking for. We were looking for those who would align with our values, our government, and our positions, and other tribes who had other agreements in law enforcement that would sync up to our case. And so there's a process that our Attorney General's office went through. I know when I sit in on numerous calls and meetings where we talked about whose briefs we would utilize. And so, as we sit here today, I'm very thankful for those people who took the time, a lot of times on their own, to write briefs in support of our case. So as we then proceeded to the Supreme Court in November 2018, we had this kind of package of all these briefs of our positions, of the attorneys, and then presented that to the Supreme Court in oral arguments. All the Supreme Court justices were there. It was quite an experience to go to the Supreme Court. As I look at you today, you can see the seal on my bolo. We could show nothing that represented any influence that may come to the judges. So I think several of us had the pin of Muskogee Nation on our lapels. They made us take them off. They wanted to make sure we looked as just anonymous as anybody else, I guess. And so we had to sit there. We couldn't take notes. They took everything that we had, pencils, papers, briefcases. We had to put them in lockers prior to walking into the courtroom. And in addition to going through the security measures, being patted down, everything else, that we had to do just to be in that room. And then where they sat us was very important because it was the first rows behind the attorneys that were presenting the case. They were front and center. Other attorneys that were supporting them maybe their second team of attorneys were behind them, and then it was us, and then others who were interested in the case. And there were people from all over the United States who wanted in there. So many that they had to have other rooms available to them where they could view the arguments remotely, but they were still in the Supreme Court building. They just didn't have room for them in the main room where we were sitting. So very much a lot of interest and a tremendous amount of media interest. So much that we had to get a local firm in Washington, D.C. just to manage the media during this time. I know that we had a number of media contacts, requests for interviews immediately after we left the courthouse. And so I did a number of interviews, the Attorney General did, because the attention of this case had gathered nationally. After the presentation of the case, we waited. This was early on in the session of the 2018-2019 session for the Supreme Court. So it was heard in November, they started in October. We knew that we may not get a decision until May or June of 2019. We continued to watch that case as it progressed, and about that time, then we saw the emergence of the McGirt case. And so we had to monitor that case as well. Initially, it's kind of like the Murphy case, we kind of wondered what the McGirt case was about. McGirt didn't have an attorney. He was representing himself as this was going through an appeal process. We watched it. We had had briefings from my Attorney General's office staff tell me where it was going, what they thought was going to happen with this case. Was it going to play a factor in the Murphy case? Because he had a similar argument. On the other side of the McGirt case, I think, in my own opinion, we had the state of Oklahoma who wanted to bring that McGirt case, because in the arguments before the Supreme Court by the opposition and the state of Oklahoma, their argument didn't sound that strong. When we left, we thought that we had a very divided Supreme Court, about maybe 4-4. And so as we left, we knew it was going to be a very close call from that court. And we got a sense of that from the questions they asked, even the posture that they had, the demeanor that these guys showed, or justices showed during the arguments was, very telling in a way. To me it was, and I think to our those of us who were in there. So we kind of gauged that split of the Supreme Court during that time. And again, in my opinion, as the McGirt case proceeded, it's almost as the state of Oklahoma wanted to get that case before the Supreme Court, because if they could do that, then they could present other things that they didn't get to under the Murphy case. And my gut feeling was the state of Oklahoma wanted that case to proceed, because then it would leapfrog the Murphy case and work in their favor. So I think, we saw that case begin to formulate, it's our opinion that there are the forces that couldn't get their briefs to the Supreme Court or arguments heard or convince the Supreme Court justices that they were using the McGirt case to put in another argument. As the Murphy case was proceeding toward a decision, the Supreme Court, this was during COVID as well, so very unusual circumstances. I mean, we were able to sit in pre-COVID for the arguments, but after that, the Supreme Court was kind of remote. They wouldn't let people in as they heard arguments. So what they decided to do with the Murphy case was to carry it over to their next session, which is, I thought, highly unusual, and what I've been told, it is very unusual. So their time to make decisions closed. What the Supreme Court decided to do was to rehear this case. So we had to prepare to re-argue the Murphy case with additional questions that the Supreme Court had to the nation. So we were preparing that as the McGirt case was proceeding. One day, I think this was like November 2019, I got a call from my Attorney General saying the Supreme Court was pulling the case in. They're going to hear the McGirt case. So immediately we had to elevate the amount of effort that we had and split the time between Murphy and McGirt, because we had to make sure the McGirt case had arguments that we had similar to Murphy to be heard. At the same time, we were preparing for reappearance before the Supreme Court on the Murphy case. So what the Supreme Court decided to do was kind of pause the Murphy case and hear the McGirt case. My term ended in January of 2020. The McGirt case had yet to be argued before the Supreme Court. So as I left and walked out the door, the McGirt case was being fast-tracked to the Supreme Court. After I left, the Supreme Court heard the McGirt case, and as we all know now, in July 2020, decided that they would rule and make the decision from the McGirt case, and then that would apply to the Murphy case. So in one day, the whole landscape changed. And so we now entered that phase where this post-McGirt decision, and this was a capital crimes case, but it very quickly mushroomed. After the McGirt decision, the courts began to rule that the other reservations of the other 4 tribes were never disestablished, and some other tribes in northeastern Oklahoma. So I think 7 tribes' reservation statuses were upheld subsequent to McGirt. That did change a lot within the state of Oklahoma and nationally as well, but mainly the state of Oklahoma. As you can imagine, the state of Oklahoma and our present governor was really upset about this case, trashed it every way they possibly could, and set to work on how they could overturn this case on a second appeal to the Supreme Court. After McGirt decision, and as of this date, we've had at least 39 cases that they pushed toward the Supreme Court to try to diminish or overturn the McGirt decision. One case, I think, is the Huerta case that was ruled by the Oklahoma Supreme Court, and I think in August of 21, said that the cases of McGirt couldn't be retroactive. So anything prior to the decision basically remained as they were, that McGirt would only apply to the July 9th, 2020 and forward. It didn't stop a lot of people, and I think even to this day, as I read some of the media about cases, people are trying to use the McGirt decision retroactively, and they're going to be probably knocked down because of the Oklahoma Supreme Court decision. Now, as we talked about some of the appeals before the Supreme Court that have happened after the McGirt decision, we need to examine this in terms of the pre-decision and post-decision. Pre-decision, we had numerous groups who opposed us that are people that we had business with within the state of Oklahoma. The Sheriff's Association of the state, Oklahoma Council of Public Affairs, oil and gas people. I think we even had some meat group, farmers group, beef group or something that opposed our case. They were against us then. After the decision, they got together and they're active as we speak today, trying to overturn this case and take away the privileges and the legal rights that we had from the McGirt decision. We still see media articles. An example was the Hughes County Sheriff that talked about the lawless, and now we're not doing anything. What's interesting is that as the tribe followed up with the sheriff, they got no response, but they got the attention that they needed throughout the media of trying to trash us publicly, but it was misleading. It wasn't in a cooperative spirit that they had before, but it reflected this association of the sheriffs that were against this and were active. Some of the judges in eastern Oklahoma, by just dismissing their cases after McGirt and washing their hands and then complaining that these people were being set free. That didn't have to happen. They could have worked with the tribes, negotiated how these cases were going to be transferred, and have a seamless transition from the state courts to the tribal courts. Most, I think, did, but a lot of them I mean, there's a number of them who just dismiss these cases and then blame the tribes. And I think that sentiment, they still, is still being shown by them. The attorney generals, the state association of the attorney generals and the county prosecutors, some of them, continue to talk about how the tribes aren't, prosecuting these cases. I think we have to look at that argument, though, on both sides. How many of these cases, if McGirt was not in existence, how many cases are brought before them on a daily basis, and how many of them are actually prosecuted? They need to show their figures before they talk about the tribe and our figures. And that way you could have an equal argument. But I think some of those groups don't want an equal argument. In conclusion, I guess I should probably, I could go on about some of the things I feel about the case and some of the people who just continue to try to erode the strength of the case. In summary there, really what the case did was really uproot the power structure in the state of Oklahoma. And that's why you see oil and gas, the law enforcement folks, they had to share power. They don't want to share power. They have enjoyed that from, I think illegally in a lot of ways, from statehood to present. And for us now to be a big player there is not, something that they want to see, because it erodes the power structure in the state of Oklahoma, and they don't want to see that. But for the nation, for our citizens, and our government, what we see now in the way that we should celebrate our sovereignty is to enjoy what we received in that decision, and recognize that it's a pause before more battles to uphold our sovereignty in the courts. But as we do so, to go back to the things that were the strength of our case before the Supreme Court, where we demonstrated that we have active ceremonial grounds, traditional values, a strong culture of our people, the language of our people, the Constitution, the agreements with other agencies in enforcing laws and other agreements for roads and transportation and things like that. We need to make sure that every day we're exercising our sovereignty in how we live our lives, so we know that that's the strength of our nation, and anything in the future that's challenged, we should be able to prevail because of the strength of our tribe. And so, my request to everybody is to make sure that we have other people know who we are, and we live the values of our nation, of our tribe, and our culture, so that that's the strength that we carry in the future, and that's the respect that we need for the others who came before us, sometimes laid down their own lives to make sure we enjoy the things that we have right now. So I'm glad that we have the Sovereignty Day. We should reflect on those days. We should be humble in those days, and then take that and build our nation for the future. Maro.